Hi, good afternoon. Thank you so much for the invitation. It's an honor to be here today, speaking this important event. Let me introduce myself. My name is Lucia Loureiro. I'm a lawyer specialized in foreign trade, and I'm also a certified conflict mediator and mediator at the AB Chamber of Conflict Mediation in Foreign Trade in Brazil. And today, I'm going to talk about conflict mediation applied to international trade, how mediation can assist in resolving disputes between international trading partners. When commercial relations, are intended to be preserved by the parties, the negotiation process, assisted by a third party, such as the mediator, helps to lead those involved to better visualize the concrete scenarios, helping them to build agreements of mutual benefits. The role of the mediator is to facilitate negotiation between the parties. But first, I think it's important to highlight the role of the Singapore Convention for Mediation. The Singapore Convention, signed on August 7th, 2019, was a milestone for international mediation. It represents facilitation of the execution of agreements signed through the mediation procedure involving disputes in international trade. This brought very strong evidence of mediation as an alternative dispute resolution method. In a current scenario of a global commercial crisis, the adoption of this convention, which privileges the amicable mediatic way in the resolution of disputes, is certainly a positive sign and a strong response to the entire international legal community. It should be noted that the scope of this convention, in addition to promoting international commercial mediation as an effective and efficient alternative, encourages the development of harmony in international economic relations. The convention, in addition to promoting mediation as an adequate method of resolving disputes at the international level, encourages the development of more harmonious relationships between trading partners, allowing for the preservation and continuity of these relationships. It is an international instrument which aims to promote certainty and stability to disputes resulting from international commerce. This more favorable framework for referring national and international disputes to mediation generates relevant direct and indirect impacts in nations that have high litigation, such as Brazil. Brazil signed the Singapore Convention on Mediation last year, together with great trading countries such as United States, South Korea, and India. And the expectation is that Brazil will become more attractive to multilateral international trade relations insofar as a possible dispute can be quickly resolved through mediation. And in the event the agreement is breached, it can be executed in a very agile and simplified way. And this attracts greater foreign investment, often repelled by the slowness and complexity of the country's justice system. The fear of foreign businessmen with divergent decisions, or the lack of predictability regarding the outcome of a lawsuit, give way to the reliability and legal certainty of a procedure that places the parties involved as protagonists in the construction of the most appropriate solution to the circumstances of the case. A dispute cannot be resolved within a reasonable time. A dispute that cannot be resolved in this reasonable time can put a company's finances at risk. So the use mediation to resolve conflicts in these contractual relationships can bring many benefits, increasing the efficiency of logistics and the competitiveness of products and services. So I will bring here an example where mediation can be well used in foreign trade business relationships. A case of demurrage, for example. Demurrage charges are unfortunately very common and sometimes unavoidable. Of course, different ports, carriers, and contractual agreements have different daily fees for demurrage. Demurrage is a penalty paid by the chatterer when he exceeds the lay time allowed, that is, the time the chatterer has to complete the loading or unloading operation. This period allowed is agreed in advance in the contract of carriage and varies according to the amount and type of cargo, type of negotiation, and so on. In summary terms, we can say that it is not a fixed rate, but a negotiable amount. Therefore, if at the time of the operation, the chatterer exceeds this allowed time, he must pay a penalty, which is demurrage. This means that if a container stays longer than the free storage time given, fines will be charged. The charge is made proportionately to the extra time used, so days, hours, and minutes, according to what was exactly stipulated. But you have the contractually accounted period for using the container. It's called free time. So when we talk about the process of loading or unloading goods, we are necessarily talking about the use of various machinery, human resources, and variables such as weather conditions and customs deadlines that may occur and cause delays in the release of goods. So therefore, it is not uncommon for the importer to delay the return of the container, causing a demurrage debt to arise, which in many cases ends up generating a very high value, resulting in a large default. In these cases, we see that lawsuits involving this issue considerably affect the commercial players involved. Not only harms the good business relationship, but also damages the image of the company. So, as you can see here, business litigation have the potential to bring unwanted consequences. Ideally, business conflicts can be settled without resorting to litigation through direct negotiations or mediation, which are often faster, more private, and less expensive than litigation. For every business, lawsuits have major drawbacks, including costs, because lawsuits can be a drain on finances, time, and resources. Besides that, publicized disputes can tarnish a company's reputation because they can decline a company's value, drive down sales, or even cause a business to fold. So my experience in that role as a foreign trade lawyer taught me that litigation was very expensive, time consuming, and that in many cases could damage the relationship with the client. So in an attempt to resolve these concerns, that I began to really appreciate the opportunities mediation presents, particularly in providing a way for parties that are in a significant business relationship and wish to continue it to resolve their disagreements. I recall having been confronted with a difficult problem involving an important client. My client exported Brazilian nuts, and due to force majeure, he was unable to send these nuts. But his client did not understand that the event of force majeure had occurred. On the other hand, for my client, the long-term business relationship was very important. So he decided to mediate rather than litigate. The goal was to craft a solution that everyone was willing to accept. Success was achieved in that matter fairly quickly and easily. And after that, I decided to consider mediation as a solution early in the dispute resolution process. So as you can see, mediation provides a comfortable environment for the parties to be listened to and understood, with the focus being an outcome both parties can agree to and move forward. And that is where we bring mediation as a possibility of a less stressful solution in every way. The mediator, who is an impartial third party, through the application of communication and negotiation techniques, helps the parties to have more clarity about the problem by identifying common, complementary, and divergent interests. This process is guided by confidentiality, where any issue brought to the mediation will be protected by this confidentiality of information. So as you can see here, the difference between litigation and mediation. So in litigation, lawsuits can be drained, as I said, on finances, energy, time, resources, and emotions, and often drive a rift between parties, and business relationships may end up severed. In mediation, it's often faster, more private, and less expensive than litigation. And the more important of all, preserves business relationship. So without further ado, in mediation, the discrete setting allows for more relaxed discussion. And in their neutral capacity, the mediator works diligently to prompt the parties to resolve the issues rather than fight over them. This process is usually much less stressful for everyone due to privacy afforded, along with the chance to find a solution tailored exactly to the needs of those involved. And the simple fact that everyone agreed to mediation and showed up is an indicator that they care about the relationship at hand. If you are a business owner worried about the outcome of a dispute, mediation may save you enormous time and money, and in the end, even preserve a valuable business relationships as you are able to work through the conflict. So as you can see here, mediation can play a role in preserving long-term business relationship. Is much quicker and less expensive process than court proceedings. If the matter reaches court, it may go on for years and is likely to be prohibitively expensive with an uncertain outcome. A successful mediation will result in a written agreement which will be legally binding on both parties and enforceable by the courts. Mediation helps to build agreements and mutual benefits. So that's it. Thank you so much. Once again, I thank so much for the invitation. Thank you for your attention. And you can, if you have any doubts, feel free to send your questions to any of these contacts here. It will be a pleasure to answer all the questions. Thank you very much.